You're going to love this. From time to time I get calls that say, Mr. Oginski, I could have died. I almost died. Would you like to learn what this is all about? Come join me as I share with you this great information. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. You can't imagine, but I get these calls from time to time where somebody calls up and says, listen, I want to bring a lawsuit against somebody and I almost died. And you know what I say in response to that? But you didn't. And that stops them cold in their tracks. But I could have. But doesn't count. Almost doesn't count. The fact that you are alive is terrific, and I'm glad to hear that. But does not count. So the mere fact that you could have died or almost died doesn't play any part in whether or not you may have a valid case. So let's say it's a medical malpractice matter, and now you believe that a doctor caused you harm because he or she violated the basic standards of medical care. And now, had this not been corrected or timely recognized in time, it's quite possible you could have died. But we can't go ahead with speculation and ultimately go to trial and say, ladies and gentlemen of the jury, this person could have died. And they turn around and say, yeah, but they didn't. So what type of injury, what type of compensation are you seeking because you almost died? That's not how it works. Instead, we have to look to see what was actually done, what was careless. We have to see whether or not that carelessness was a cause of your particular injuries. And then we need to look at what were your injuries? What harms and losses did you suffer as a result of that carelessness? Only then can the jury make a determination. If they find that we are more likely right than wrong, that somebody was careless and that carelessness was a cause of your injuries, then they look to see the extent of your injuries. And you will find that most good, experienced trial attorneys who handle medical malpractice cases or accident cases are typically not going to take on cases that have very minimal injuries. Plus, they're not going to take on cases that are speculative. You want to know why? Because a jury will not be permitted to give compensation to an injured victim for speculative injuries. And if the injuries are speculative, then there's no way we can go forward, and there's no way that ultimately a jury would be able to give you compensation for the harms and injuries that you suffered. So why do I share this quick tidbit of information with you? I share it with you to give you an insight and an understanding to what goes on in the litigation process, especially in a medical malpractice case that I've just described. You know, I realize you're watching this because you have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Jerry, G-E-R-R-Y, @oginski-law.com. That's it for today's quick video. I'm Jerry Oginski. Have a great day.